Count 2, felony 1 kidnapping with the attached 3-year firearm specification and forfeiture specification. Count 5, felony 3 abduction with the attached 2-year school zone safety specification. Counts 7 and 8, both being misdemeanor 1, endangering children. Count 9, felony 4 assault on a police officer. And count 10, felony 4 inducing panic. On case number 24 CR 1460, an amended count 1, which is amended to felony 5 obstructing official business in violation of revised code 2921.31A. All remaining counts and specifications would be dismissed by the state at the time of sentencing. Prison is mandatory in this case, but there is no specific agreement on sentencing at this time. The defendant may recommend any sentence within the legally permissible range. The state is going to recommend 12 years in prison. Prior to coming into court today, I did discuss and convey this plea offer to all the victims in this case, so they have been notified and are aware.
Count 1 in the second case is the aggravated robbery.
Yes, Your Honor.
That's being amended to obstruct being official business.
Yes, Your Honor.
And you step forth what the state's recommending, but that's just your recommendation. The defense is free to recommend whatever sentence they believe is appropriate within the lawful range, correct?
Yes, Your Honor.
Okay. Ms. Smith, does that all sound accurate?
It does, Your Honor.
And Mr. Sinclair, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your plans are here this afternoon?
Yes, Your Honor.
You know, sir, you can be seated during this process. It takes a while. I don't interpret that as any disrespect, so it's easier to be sitting down. But just make sure you keep your voice up so we could hear you, please.
Yes, sir.
All right, so you're able to hear what everybody had to say?
Yes, Your Honor.
As represented in the court, they believe it's your desire at this time, in each of these cases, to withdraw your previously entered pleas of not guilty and enter pleas of guilty to certain charges in each case. And I'll go over those with you to make sure you understand exactly what it is you're pleading guilty to. The remaining counts of the indictment in the first case, in both cases, would then get dismissed. We would defer sentencing to a later day to get some evaluations and reports completed. Come back on a future day for sentencing where the state has indicated that they will be recommending, or agree, I should say, not to recommend more than an overall total for both cases, right, Mr. Downing? That 12 years is for both cases together?
Yes, Your Honor. It's a global resolution.
And that's the minimum sentence, though, right? The minimum, it's an indefinite.
Yes, the state's recommendation would be just the time before factoring in the Senate Bill 201 time. So in the state's recommendation, it would be an indefinite range that would go a little bit above 12. And I don't have the specific breakdown, but you're correct.
So the state would be recommending a minimum sentence, would not recommend more than a minimum sentence of 12 years, but you're free to recommend whatever sentence you believe is appropriate under the circumstances, again, within the lawful range. Understand that?
Yes, Your Honor.
And that's what you agree to?
Yes, Your Honor.
Well, then before I can accept your guilty plea, I need to make sure you understand everything we're doing here. I need to make sure you understand what you're charged with in pleading guilty to, the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I will ask you at this time a series of questions. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you'd like a moment to talk with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything going on, all right?
Yes, Your Honor.
All right. Well, let's get started then. And when I go over all this information, everything applies to both cases, especially particularly your rights. But if there's anything that applies to one case and not the other, I'll make sure I point that out to you. But otherwise, everything is applying to both cases. I'm not going to go over, advise you of your rights twice for each case. All right?
Yes, Your Honor.
All right. Let's get started then. How old are you, sir?
34 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No, Your Honor.
What about within the last 48 hours?
No, Your Honor.
Not even prescribed medication, nothing?
Nothing, sir.
Now, you would have been served with copies of each of the indictments in each of these cases. In the first case, it looks like you probably would have gotten sometime in the middle of December. And then the second indictment, you would have gotten around the same time, actually, maybe a week later or so. Did you get both of those indictments?
Yes, Your Honor.
At some point you had a chance to look those over, did you?
Yes, Your Honor.
Well, in the first case, that was indicted, that's case 24 CR 1320. It was a 14-count indictment. You're pleading guilty to 6 charges in that count. So I'm going to go over those 6 charges with you. If you have any questions, make sure you ask. But the first count you're pleading guilty to is count 2. And what is alleged here and what you're admitting to is on or about October 31st, 2024 in Painesville Township, Lake County, Ohio, that you did by force, threat, or deception remove another from the place where the other person was found or restrain the liberty of the other person with purpose to terrorize or inflict serious physical harm on the victim or another. That conduct constitutes the offense of kidnapping. It's a felony of the first degree. Do you understand what you're charged with and pleading guilty to in regards to count 2?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
It's the first specification he's pleading to, correct?
For count 1, the 3.
Oh, right, the third one's forfeiture, never mind.
Yes.
This count also carries with it a forfeiture specification that you're pleading guilty to, which alleges that you had a firearm on or about your person under your control while you committed the offense, and you displayed the firearm, brandished the firearm, indicated you possessed the firearm, or used the firearm to facilitate the offense. You understand what you're pleading guilty to in regards to that firearm specification?
Yes, Your Honor.
There's also what we call a forfeiture specification as a part of this that alleges during the commission of the offense you had in your possession a Glock 26 semi-automatic pistol with a magazine and ammunition that were used as instrumentalities. Instrumentalities is some type of property that's used to facilitate the commission of an offense. The purpose of this specification is that at the time of sentencing you will forfeit any ownership interest you have in the property listed here, which is, again, the firearm and the magazine and ammunition. You understand that? It doesn't increase any potential penalty or require any additional possible incarceration. Just it's a forfeiture of your ownership interest. You understand that?
Yes, Your Honor, I understand.
Any questions about that?
No, Your Honor.
Now, there is a specification as part of this for the school safety zone that's being dismissed as a part of this agreement. Is that your understanding?
Yes, Your Honor.
Now, the next count you're pleading guilty to is count 5. Count 5 alleges, and what you'll be admitting to is on or about October 31st, 2024 in Painesville Township, Lake County, Ohio, that you did without privilege to do so knowingly, by force or threat, restrain the liberty of another person under circumstances that created a risk of physical harm to the other person or placed the other person in fear. That conduct constitutes the offense of abduction. It's a felony of the 3rd degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, this count contains a specification that alleges that during the commission of the offense, that you did commit a felony of the 1st, 2nd, or 3rd degree. That is an offense of violence, that being abduction, that I just described to you and read to you. And you did that in a school safety zone or towards a person in a school safety zone. Do you understand what's alleged in that specification and what you'll be admitting to?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, counts 7 and 8 each charge the offense of endangering children. What's alleged in each of these counts is that on or about October 31st, 2024 in Painesville Township, Lake County, Ohio, that you, being the parent, guardian, custodian, person having custody or control, or person in local parenti of a child under 18 years of age, that you did create a substantial risk to the health and safety of that child by violating a duty of care, protection, or support. There's 2 different children for each of those counts, right, Mr. Downing?
Yes, Your Honor.
So that's what the 2 counts involve. 2 different children, one for count 7, the other for count 8. That constitutes the offense of endangering children. Each misdemeanors of the 1st degree. Do you understand what you're charged with and pleading guilty to in regards to counts 7 and 8?
Yes, Your Honor.
In count 9, what's alleged here and what you're admitting to is on or about October 31st, 2024 in Painesville Township, Lake County, Ohio, that you did knowingly cause or attempt to cause physical harm to Deputy Al Ward, the victim being a peace officer while in the performance of his official duties. That constitutes the offense of assault. It's a felony of the 4th degree. Do you understand what you're charged with and pleading guilty to in count 9?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Lastly, in count 10, what is alleged here and what you're admitting to is on or about October 31st, 2024 in Painesville Township, Lake County, Ohio, that you did cause the evacuation of a public place or otherwise cause serious public inconvenience or alarm by committing any offense with reckless disregard of the likelihood that its commission will cause serious public inconvenience or alarm. It's further alleged the violation resulted in physical harm to any person, which constitutes the offense of inducing panic. It's a felony of the 4th degree. You understand what you're charged with in pleading guilty to in count 10?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
Now, the specifications contained in that count are being dismissed. Is that your understanding?
Yes, Your Honor.
And likewise, all the other counts of this indictment are being dismissed, as well as any of the specifications that I didn't review with you. Is that your understanding as well?
Yes, Your Honor.
Any questions about any of those charges or other specifications that are being dismissed?
No, Your Honor.
Now, in the other case, it's 24 CR 1460. You're charged in a 5-count indictment. Count 1 is a charge of aggravated robbery. The state of Ohio, however, has agreed to amend this charge to a count of obstructing official business. So I want to make sure you understand what obstructing official business is, and if you have any questions, you can ask. But what you'll be admitting to in regards to this amended count is that you, on October 31st, 2024, in Painesville Township, Lake County, Ohio, did, without privilege to do so, and with purpose to prevent, obstruct, or delay the performance by a public official or any authorized act within the public official's official capacity, that you committed an act that hampers or impedes the public official in the performance of that public official's lawful duties. That conduct constitutes the offense of obstructing official business, and it's a felony of the 5th degree. So that's the amended count that's being, that's what aggravated robbery is being amended to that, and that's what you'd be pleading guilty to. You have any questions about that?
No, Your Honor.
Now, the other 4 counts of that indictment then will be dismissed. Is that your understanding as well?
Yes, Your Honor.
Any questions about any of those?
No, Your Honor.
Well, then before I can accept your plea of guilty to the charges I just reviewed with you, and that were set forth on the record here, I need to make sure you understand all the rights you are giving up. And again, I'm going to go over these one time, but they apply to both cases, all right? And you, first of all, do have a right in each of these cases to have a trial. And that trial could be to me as a judge, or I would listen to all the evidence and I'd make that decision whether you're guilty or not guilty of each charge. But you also have a constitutional right to have a jury trial, and that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. Those 12 jurors would consider and weigh all that evidence, and then those jurors would make that ultimate decision. And that ultimate decision reached by those jurors would have to be unanimous. What that means is all 12 jurors would have to agree together, one way or the other, as to each separate charge, whether you're guilty or not guilty. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to have a trial and a jury trial?
Yes, Your Honor.
Now, if we had a trial in either of these cases, the state of Ohio here would be represented by the assistant prosecutor. He would have what we refer to as the burden of proof. With him having the burden of proof, what that actually means is that it's his job, or he bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of all these charges. And that presumption of innocence sticks with you and remains with you until the state, if at all, is ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes, Your Honor.
Now, when I speak of this burden of proof, since this is a criminal case, the burden of proof is what we refer to as proof beyond a reasonable doubt. And that's the highest burden there is in our justice system. What it actually means, it's the amount of the evidence and the quality of the evidence that the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of all these charges beyond any reasonable doubt before you could ever be found guilty at a trial of any of these charges. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
Yes, Your Honor.
Now, in order to try to do that, if we were going to have a trial in either of these cases, the prosecutor would bring witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront those witnesses that would come in here and testify against you?
Yes, Your Honor.
Now, you'd also have the right at a trial, you can call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order, and we call that order a subpoena. What a subpoena would do is it would force or make someone come to court and testify for you and answer your lawyer's questions if that person or persons didn't want to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision. That is a choice that you and you alone would have to make. So what that really means then is that nobody else could force you or make you Nobody could compel you to testify against yourself at a trial. If you didn't want to, I can't make you testify. But most importantly, the prosecutor here, he would not be allowed to call you as a witness at either of these trials, force you to get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we went to trial in either of these cases and you were found guilty of any of these charges, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal any guilty finding that I will enter if I accept your plea, as well as any other issues that you could have raised or challenged or brought to my attention up to this date. Do you understand that?
Yes, Your Honor.
All right, Mr. Sinclair, then, do you have any questions at all regarding these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
No, Your Honor.
Do you understand them all?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Now, do you understand a guilty plea is a complete admission of guilt? It means you're admitting to the facts being alleged by the prosecutor. We're not going to argue later that you didn't do it or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of that plea is that you'll be found guilty by the court, and then you will subsequently, on a future day, be sentenced by the court. Do you understand that?
Yes, Your Honor.
Now, as far as possible sentences go, we'll go with the 24 CR 1460. That's the case where you're pleading to obstructing official business. That offense is a felony to the 5th degree. That is punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. Do you understand that?
Yes, Your Honor.
Now, in the next case, 24 CR 1320, which actually was the first case, the kidnapping charge is a felony of the 1st degree. This offense requires that an indefinite prison term be imposed, if a prison term was going to be imposed, of a minimum of 3 years, a maximum of 11 years, or any whole number in that range. So I would select, if I'm going to impose a prison term on this kidnapping charge in count 2, I don't know if it's count 1, but it's count 2, a number 3, 4, 5, 6, 7, 8, 9, 10, or 11, whatever number I selected would be the minimum sentence of part of that indefinite sentence. You understand that?
Yes, Your Honor.
Now, the way the maximum sentence then is determined, it's a simple mathematical formula. You take half of whatever the minimum sentence is, you add it to the minimum, and that becomes the maximum. So, for example, if I select 3 years as the minimum, half of that is 1.5. I'd add the 1.5 to the 3. Your maximum becomes 4.5, so it'd be 3 to 4.5 years. Another example, if I selected 8 years as the minimum sentence, half of that is 4. I'd add the 4 to the 8. Your maximum becomes 12, so it's 8 to 12 years. The maximum sentence, if I chose the 11 years as the minimum, half of that is 5.5. I'd add that to the 11. Your maximum sentence then is 16.5, so that'd be the maximum sentence, 11 to 16.5 years on count 1. Count 2. You understand that?
Yes, Your Honor.
Now, this charge also carries with it a 3-year firearm specification, which requires the court to impose a mandatory prison term of 3 years that must be served prior to and consecutive to any other sentence that gets imposed by the court. Do you understand that?
Yes, Your Honor.
Now, in count 5, you're charged with abduction. That's a felony of the 3rd degree. If a prison term is punishable by a possible term in prison of a minimum of 9 months, a maximum of 36 months, or certain increments in between of either 12, 18, 24, or 30. So if a prison term is imposed in this count, I'd select one of those numbers, 9, 12, 18, 24, 30, or 36, and that'd be the number of months in prison you have to serve for count 5. Do you understand that?
Yes, Your Honor.
Now, this count also carries with it what we call a school safety zone specification. This specification requires the court to impose a 2-year prison term, which would be a mandatory prison term. That would have to be consecutive to the abduction. It's just not consecutive to the firearm specification, correct?
Yes, under 2929.14, the court shall impose upon the offender an additional prison term of 2 years.
Right.
The offender shall serve the additional 2 years consecutively to and prior to the prison term imposed to the underlying offense, but
These two specifications don't have to be consecutive.
correct, the statute is silent on that.
So for this specification, school safety zone specification, the 2-year sentence, it's mandatory, would be served prior to and consecutive to whatever prison term is imposed for the abduction. You understand that?
Yes, Your Honor.
Now, counts 7 and 8 are misdemeanors of the 1st degree. These are each punishable by a possible term of local jail incarceration in Lake County Jail of up to 180 days on each count. Do you understand that?
Yes, Your Honor.
Counts 9 and 10 are the assault and the inducing panic. Each of those are felonies of the 4th degree. They are each punishable by a possible term in prison of a minimum of 6 months, a maximum of 18 months, or any whole number in that range of 6 to 18. Do you understand that?
Yes, Your Honor.
Now, there are here, what was the total? 6 charges you're pleading guilty to. The prison term is imposed on each of those 6 charges. I indicated that the specifications have to be consecutive to the prison term for that offense. But as the judge, I would have the discretion to order the prison terms themselves to be served concurrent or consecutive to each other. So there's, of the 6 counts, 4 of them could involve prison terms. The misdemeanors can't involve prison terms. But those 4 counts, if I impose a prison term on each of those 4, I could run those prison terms concurrent or consecutive. Concurrent means you serve them together at the same time. Consecutive means one after the other. You serve the prison term on one count, finish it, then the next, and then you do the indefinite sentence. Now, the misdemeanors, any jail time that's imposed for the misdemeanors by law has to be served concurrent with the prison term. So I can't make the jail sentences consecutive to a prison term. So that by law would have to be concurrent with any prison term. You understand that?
Yes, Your Honor.
So for this particular case, I need to be assured you understand the maximum sentence you face. If I impose the maximum sentence on each count and ran them all consecutive to each other along with the specifications, you're looking at a maximum possible indefinite prison term of a minimum of 16 years, a minimum of 17 years. Why do you have 16 on there? Oh, that's the other case. Never mind. That's the other count. Let's go with the other count. For this particular case, it'd be a minimum of 16 years, maximum of 22 years, plus the 5.5 years for the, plus the 5 years for the specifications. So it'd be a total of 21 to 27.5 years on this case. You understand that?
Yes, Your Honor.
I also would have the discretion to run any...
22 to 27 and a half.
What did I say?
21.
Oh, I meant 22. That's my head. It'd be an indefinite sentence.
Isn't it 28 and a half?
That's with the next case. And 22 to 27 and a half years on the first case. The other case where I can give you a 6 to 12 months on the obstructing official business, I can run that consecutive as well. So altogether, the maximum would be 28 and a half years. You understand that?
Yes, Your Honor.
Any questions about that?
No, Your Honor.
That's a little confusing. It could be a lot confusing, but you understand that?
Oh, I understand, Your Honor.
Now, are you currently on probation, community control, post-release control, any supervision to any other courts or agencies?
No, Your Honor.
Do you have any other charges pending against you in any other courts?
No, Your Honor.
In this case, if a prison term is imposed, post-release control would be imposed. Post-release control is sometimes referred to as parole. It's a period of supervision you would be on after you served and completed the prison sentence. And in this case, it's mandatory for a period of 5 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control at any point, never violated any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each separate violation you committed, up to an overall maximum of 50% or half of the prison term imposed by this court. Do you understand that?
Yes, Your Honor.
Now, this post-release control I just advised you of is for case 24 CR 1320. In the other case, post-release control is not mandatory. You could be put on for up to 2 years. Do you understand that?
Yes, Your Honor.
Now, a couple other matters I want to advise you of before I move on. As I indicated, for count 2, it requires an indefinite prison term be imposed. An indefinite prison term, again, means there's a minimum and a maximum sentence that is imposed. There will be a presumption for this particular count that you will be released after you have served the minimum sentence that I imposed for that particular count. Now, if sentences are consecutive, you have to serve those sentences first. But then once you get to the indefinite sentence, there is a presumption that you would be released after you have served whatever that minimum sentence is. Now, just because there's a presumption that you'll be released at that point doesn't mean that's guaranteed. If at the end of serving that minimum sentence, if while you were in prison you misbehaved, you didn't follow the rules of the institution, you weren't sufficiently rehabilitated in the eyes of the parole board, they could have a hearing. And if at a hearing it was determined that you did commit rule violations or infractions while you were in prison, again, not sufficiently rehabilitated, still constituted a threat, they could not release you at the minimum sentence. They would then pick another date to set forth as your release date, and there'd be a presumption that you'd be released at that new date. and the same procedure would follow. Be a presumption you'd be released, but again, if you continue to misbehave or not follow the rules, they could deny you being released at that point. However, under no circumstances can they keep you in beyond the maximum sentence that's imposed by this court. Even if you hypothetically misbehaved the whole time you were there, committed rule violations, they have to release you after you serve the maximum sentence. You understand that?
Yes, sir.
Now, you would also have the ability, while serving your prison sentence, to earn what is called prison credit. It could be a credit anywhere between 5 to 15% of the time that you served. It's based on exceptional conduct while you are on prison, sort of the opposite of what we were just talking about. The prison officials would determine whether you're entitled to any of that credit, and there would be a presumption, if they do say you're entitled to it, that you'll be granted that credit. However, I would get notified, or whoever the judge was sitting here at that time would get notified, and that judge would have the right to disapprove of that. Now, if the judge wanted to disapprove of that, there'd have to be a hearing here in court, and you'd be brought back for that hearing. And after that hearing, the judge can either approve or disapprove of it. However, if the judge doesn't bring you back, then it would have to be approved. And there's a presumption that it would be approved. You understand that?
Yes, Your Honor.
All right. Now, I just reviewed with you the prison terms that can be imposed. There are other sanctions that could be imposed as well. In the case of the obstructing official business, there's a possible fine of up to $2,500. In case 24 CR 1320, the kidnapping charge carries with it a possible fine of up to $20,000. The abduction charge carries a possible fine of up to $10,000. The two endangering children charges carry with it possible fines of up to $1,000 each. And the two felonies of the fourth degree, the assault and the inducing panic, each carry a possible $5,000 fine. So altogether in that case, there's a possible fine of $42,000. With the obstructing official business, there's a maximum possible fine of both cases of $44,500. None of those fines are mandatory, however. They're all up to the court to decide. You understand that?
Yes, Your Honor.
Now, you could also be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment if any of that were applicable. You understand that?
Yes, Your Honor.
You could also be ordered to pay restitution for any victim, for any economic loss any victim may have suffered as a result of the criminal conduct involved. You understand that?
Yes, Your Honor.
Now, in this case, Mr. Sinclair, I need to advise you that prison is mandatory due to the firearm specification and the school safety zone specification. A court will have to impose a prison sentence at the time of sentencing. You understand that?
Yes, Your Honor.
Now, technically, the court could also order that you be put on community control sanctions, which is another term for probation, after you've served mandatory sentences for any of the specifications. But you understand, just because you're eligible for that doesn't mean it's automatic.
Yes, Your Honor.
I also need to advise you that if you're sentenced to a prison term, you would have the right to request the court grant you judicial release. Judicial release is a motion that you can file, again, with the trial court, me, or again, whoever's here at the time, requesting that you be released from prison early and placed on a period of probation to the court. Now, you're not eligible to request judicial release while you're serving any mandatory prison sentence. So while you're serving any prison sentence for the firearm specification or the school safety zone specification, you would not be eligible to request judicial release. However, once you've completed serving the any mandatory sentence, you could become eligible for filing judicial release after you've served a certain amount of time. That's all based on whatever the sentence is. But there would become a point in time when you would be eligible for to apply for judicial release. You understand that?
Yes, Your Honor.
You understand, just because you're eligible at some point doesn't mean that, again, that's automatic and it's going to get granted. It means you have the right to apply for it. The court would consider that and the court would make its decision.
Yes, Your Honor.
I also do want to go back to one thing when I was explaining the good time credit that you could receive. You are not entitled to earn good time credit based on mandatory sentence. You will begin earning any good time credit after you've served any mandatory sentence. So the mandatory sentence in this case will be either 3 or 5 years, depending. That period of time, you're not entitled to earn good time credit on that period of time. Understand that?
Your Honor.
It will be any period of time after that. Any questions about that?
No, Your Honor.
Lastly, Mr. Sinclair, at the time of sentencing in this case, you will have the right at that time to say anything you want. Anything you want me to know or consider. Your lawyer could speak on your behalf. She's allowed to recommend a sentence to the court. The prosecutor could also recommend a sentence to the court. Do you understand that?
Yes, Your Honor.
Now, do you understand that whatever anyone says at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation, and I don't have to go along and file that if I didn't think that was the right thing to do. You understand that?
Yes, Your
All
Honor.
right, well, do you have any questions at all then regarding these potential penalties you face by pleading guilty here today?
No, Your Honor.
You understand all the potential consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Okay, so Counselor, just real quick. I apologize for that. I just wanted to make sure you're accurate. All right. So I think I was asking you, Mr. Sinclair, again, you understand all the possible penalties. Any questions behind those?
No, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time with both of these cases to talk about this with your lawyer, have her go over everything with you, answer your questions, review everything?
Yes, Your Honor.
Are
Plenty
you
of time.
satisfied with the advice and counsel of your attorney in these cases?
Yes, Your Honor.
Has she or has anyone made any promises to you about what's going to happen at sentencing, which is inducing you or causing you to plead guilty here today?
No, Your Honor.
Have you been threatened or coerced in any way to plead guilty to any of these charges?
No, Your Honor.
Are you entering your guilty pleas here today freely and voluntarily?
Yes, Your Honor.
All right, then what we're going to do at this time is the prosecutor is going to explain for me what he believes the evidence in both of these cases would establish if we had a trial. I need you to listen to what he says, because then I'll have some follow-up questions for you. So, Shadani, why don't we start with the main case first, and listen to those, and then we'll do that, and then we'll go to the second case.
Thank you, Your Honor. If this matter were to proceed to trial, the evidence would have shown that at all times relevant to this case, the defendant was legally married to Lisa Chorba. The date of this offense was their 4-year anniversary. They share a 3-year-old daughter together, Charlie. Lisa also has other 2 kids, 10-year-old son Carson and 5-year-old son Sebastian. And at the time relevant to this case, the defendant was residing with Lisa, their daughter Charlie, and their 5-year-old son Sebastian in Lake County. The defendant was also employed as a police officer with the City of Cleveland Police Department. On October 31st, 2024, at approximately 7 a.m., Lisa went to her daycare job at Child Time of Painesville at 2603 Riverside Drive, while the defendant stayed behind with 3-year-old Charlie and 5-year-old Sebastian. Shortly after arriving at work, Lisa went to pick up 10-year-old son Carson from his father's residence nearby. Carson attends Riverview Elementary School, which is at 845 Madison Avenue in Painesville Township, Lake County, and that is approximately 2 miles away from Child Time Daycare. Because Riverview was not open yet, Lisa took Carson back to the daycare for a little bit, and at approximately 8:59 a.m., John Allerheiligen, who, unbeknownst to the defendant, was involved in a romantic relationship with Lisa, arrived at the daycare, intending to drive with Lisa to drop Carson off at Riverview and then get breakfast before returning back to Child Time of Daycare later that morning. 3 minutes later, at 9:02 a.m., the defendant is seen entering the Child Time lot, driving his Hyundai Santa Fe, and around that same time, Lisa, Carson, and John exit the daycare building and get into Lisa's Buick Enclave, with Lisa driving, John in the front passenger seat, and Carson in the rear passenger seat. As Lisa was starting to leave, the defendant appeared by surprise on foot outside of her car on the passenger side and began punching the passenger side window until it shattered, but it remained in place. Lisa was able to drive away, but the defendant got back into his car and followed her down Madison Avenue towards Riverview at what witnesses described was an extremely high rate of speed. Witnesses in the area of Madison Avenue told police they observed the defendant weaving in and out of traffic and passing multiple cars, and estimated his speed at 80 to 90 miles an hour, although that is not scientifically proven, but they did observe him at a high rate of speed. At about 9:05 a.m., Lisa arrived at Riverview and dropped off Carson near the entrance, and the defendant also entered the school parking lot and parked his vehicle waiting for Lisa. Riverview opens around 9 a.m., and so this time in the morning was very busy. It was drop-off time. The parking lot at Riverview was filled with multiple buses and parents and cars actively dropping off their children for the start of the school day. After dropping off Carson, Lisa drove her vehicle away from the entrance and came upon a stop sign within the parking lot of the school zone. And as she stopped, the defendant drove across the parking lot and through a grassy area, hitting her car on the driver's side. blocking the roadway. The defendant then exited his vehicle and pointed a Glock 26 9mm semi-automatic pistol towards the front windshield of her car and approached the passenger side again. The defendant pulled the shattered window from the passenger side out, reached inside the vehicle, and grabbed John, pointing the gun at his head while threatening to kill him. John pleaded with the defendant not to kill him, and Lisa tried to intervene by pulling John towards her and trying to place her hand in between the gun and John's head. Lisa then called 911, and multiple other parents and school officials who were witnessing this also called 911. During the struggle and while leaned inside the vehicle, the defendant pointed that Glock firearm towards the front windshield and fired one round, which exited out of Lisa's Buick front windshield and struck the top of the defendant's vehicle, which was right next to the Buick, in which Charlie, the 3-year-old, was still seated. A spent 9mm casing was later found on the front passenger seat of Lisa's vehicle. The defendant then opened up the passenger door, pulled John out by his hair, and told him to get on the ground. The defendant again pointed the gun at John and threatened to kill him. At this time, Lake County Sheriff's Office school safety officer assigned to Riverview Elementary School, Deputy Al Ward, witnessed this disturbance and heard the gunshot and started running towards the vehicles from where he was stationed at the front school entrance for drop-off. As Deputy Ward got closer, he observed the defendant holding a firearm over John, who was on the ground. So Deputy Ward drew his department-issued firearm and ordered the defendant to drop his gun, which the defendant did. Deputy Ward then ordered the defendant to kneel on the pavement and lie face down. However, the defendant refused to continue to comply with these orders and stated that he wanted to die and that Deputy Ward would have to kill him. Deputy Ward holstered his firearm and drew his taser, but the defendant charged at Deputy Ward and struck Deputy Ward in the chest, pinning him up against one of the vehicles, and they engaged in a physical struggle. Deputy Ward was able to deploy his taser and take the defendant to the ground. Shortly thereafter, additional Lake County Sheriff's Office deputies arrived on scene and were able to assist in taking the defendant into custody. During the struggle, Deputy Ward suffered a dislocated finger, which he went to the hospital to have reset. John also sustained scrapes across his body and a portion of his hair pulled out from his head. And the defendant also sustained lacerations to his hands and arms, which required medical treatment at the hospital. Per Lake County Police Department's policy, every on-duty police officer in all of Lake County began to respond towards Riverview with emergency lights and sirens once Lake County Central Dispatch radioed that there was a shooting at the school. After the defendant was taken into custody and it was learned what actually was happening, many of these departments were called off. However, at least 50 law enforcement officers and fire department personnel from Lake County Sheriff's Office, Painesville Police Department, Madison Township Police Department, Mentor Police Department, Perry Police Department, the Ohio State Highway Patrol, and Painesville Township Fire Department responded to the scene. As a result of the incident, Riverview Elementary School was placed into an immediate lockdown and Madison Avenue was shut down. Many concerned parents who received notice of a shooting at the school drove to the area and began to gather outside of the lockdown zone, and news crews also arrived on the scene. Riverview then began a coordinated and slow process with law enforcement to release the students back to their parents, and the area remained closed until approximately 12:30 p.m. For purposes of the indictment, because I don't believe it was listed in the filed indictment, Count 2, the kidnapping, pertains to John Allerheiligen. Count 5 pertains to Lisa Chorba. Count 7 pertains to Carson McKinney. Count 8 pertains to Charlie Sinclair. Count 9 pertains to Deputy Al Ward. And Count 10 pertains to John Allerheiligen and or Deputy Al Ward.
Inducing canon?
Yes, Your Honor.
Oh, in regards to the special finding you're talking about.
Yes, Your Honor.
All right, Mr. Sinclair, were you able to hear what the prosecutor just had to say regarding what he believes the facts and evidence in this case would show if we did go forward with the trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as he just presented them to the court? Are those facts true? Did you do what he said?
Yes, Your Honor.
Very well, then, regarding Count 2, charging with kidnapping, a felony of the first degree, what is your plea to that count?
Guilty, Your Honor.
Regarding the 3-year firearm specification that is contained within Count 2, what is your plea to that?
Guilty, Your Honor.
As for count 5, charging you with abduction, a felony of the 3rd degree, what is your plea to that?
Guilty, Your Honor.
As for the 2-year school safety zone specification, how do you plead to that?
Guilty, Your Honor.
As to counts 7 and 8, each charging you with the offense of endangering children, each misdemeanors of the 1st degree, how do you plead to each of those 2 counts?
Guilty, Your Honor.
As to count 9, charging with assault on a peace officer, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
And lastly, regarding count 10, charging with inducing panic, a felony of the 4th degree, what is your plea to that count?
Guilty, Your Honor.
All right, Mr. Downing, if you could proceed with the facts regarding case 24 CR 1460 and amended count 1.
Thank you, Your Honor. In regards to case number 1460, amended count 1, amended to a felony 5, obstructing official business, the actual, because it's not an indictment, just the actual code section would say that no person without privilege to do so in the purpose to prevent, obstruct, or delay the performance by a public official or any authorized act within the public official's official capacity shall do any act that hampers or impedes a public official in the performance of the public official's duties. Whoever violates that section is guilty of obstructing official business. It's a misdemeanor of the 2nd degree unless the violation creates a risk of physical harm to any person. Then it is a felony of the 5th degree. As this court heard previously, there was a physical struggle that ensued between Deputy Ward and the defendant. After Deputy Ward holstered his department-issued firearm, the defendant then charged Deputy Ward, and they engaged in a physical struggle. During that struggle, Deputy Ward told responding officers that he felt a tug on his holstered firearm. That firearm was not removed from its holster. And at the time, Deputy Ward believed that this was an attempt by the defendant to remove his firearm. However, with the amended count today, the state is not saying this was the defendant's intent, just that it did create a risk of physical harm during that struggle for purposes of the obstructing official business.
Thank you. Mr. Sinclair, were you able to hear what the prosecutor had to say regarding what he believes the evidence would show, and in particular with the amendment, not the conclusion that they've reached, but just with the conduct and what that led the deputy to believe?
Yes, Your Honor.
What, if anything, do you have to say about those facts he presented them? Are those facts true, and did you do what he said?
Yes, Your Honor.
Very well, then, regarding amended count 1, charging with obstructing official business, a felony of the 5th degree, what is your plea to that count?
Guilty, Your Honor.
All right, I have with me here, Mr. Sinclair, 2 documents. One for case 24 CR 1460 as a 4-page document called a written plea of guilty and judgment entry. The other for case 24 CR 1320 as an 8-page document, written plea of guilty and judgment entry. They basically set forth everything I've just explained to you regarding all the rights you're giving up, the penalties you face, what you're pleading guilty to, different issues in regards to the minimum sentence, maximum sentence, when you have to be released, etc. Before I can accept your guilty pleas in either of these cases, I need to make sure you understand what's set forth in these documents and that you sign them here in open court. Now, my understanding is that before I came out here today, you had a chance to go over these documents with your lawyer. Is that correct?
Yes, Your Honor.
Ms. Smith, is that accurate? Did you review these with Mr. Sinclair, go over them, answer his questions?
Yes, Your Honor. On a prior day, I did in fact take the written plea of guilty over to the jail, reviewed it in detail with Mr. Sinclair, had opportunity to answer all of his questions, and left a copy with him for further review.
When you went over it with him, did he indicate an understanding of it to you?
He did, and he affirmed that understanding here today.
Is that correct, Mr. Sinclair?
Yes, Your Honor.
So you understand the contents of these 2 documents and what they state?
Yes, Your Honor.
Do you have any questions for me at all regarding anything set forth in any of these documents?
No, Your Honor.
Now, it also appears that you signed these documents. The 8-page document, there's a couple signatures that appear to be your signature, and in the 24 CR 1460, there's 1 signature. Did you sign these documents?
Yes, Your Honor.
Ms. Smith, did you witness those signatures?
I did, and I affixed my signature to the same.
Mr. Downing, you as well for both cases?
I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written pleas of guilty. Let the record reflect the defendant was here in open court with his lawyer. He was advised of all his constitutional rights and made a knowing, intelligent, and voluntary waiver of all those rights. The court also finds the defendant understands the nature of these charges, the effect of these guilty pleas, as well as all the maximum penalties that can be imposed. Finding this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea and find the defendant guilty in case 24 CR 1320 to count 2, kidnapping, a felony of the 1st degree, in violation of 29 2905.01, I believe it is, 2905.01A3, along with the 3-year firearm specification. As to count 5, I'll accept the defendant's plea and find the defendant guilty of abduction, a felony of the 3rd degree, in violation of 2905.02A2 with the school safety zone specification. I'll accept the defendant's plea to counts 7 and 8 and find the defendant guilty of each of those 2 counts, being endangering children, misdemeanors of the 1st degree, each in violation of Revised Code Section 2919.22A. I'll further accept the defendant's plea to count 9 and find the defendant guilty of assault, a felony of the 4th degree, the victim being a peace officer, in violation of 2903.13A. And lastly, I'll accept the defendant's plea and find the defendant guilty of count 10, inducing panic, a felony of the 4th degree, in violation of 2917.31A3. I will also find the defendant guilty of the forfeiture specification in count 2. I think I omitted that. All the remaining counts of this case will be dismissed at the time of sentencing. As for case 24 CR 1460, I'll accept the defendant's plea to the amended count and find the defendant guilty of amended count 1, obstructing official business, a felony of the 5th degree, violation of 2921.31A. All the remaining counts of this case, 24 CR 1460, will be dismissed at sentencing as well. However, I'm going to defer sentencing in both cases at this time. I'm going to order a pre-sentence report and investigation, victim impact statements. Any other reports that you're requesting, Ms. Smith?
No, Your Honor. Well, may I have a second?
Sure.
Your Honor, can we have a psychological
Yeah,
evaluation
I was
as well?
going to order that. You didn't ask for it, so I'm going to order a psychological evaluation as well. Victim impact statement, pre-sentence investigation. Bond is going to remain the same in each case. There shows no bond in 24 CR 1320 and 1460. I think bond is at 500,000 cash surety. Mr. Sinclair, you're going to meet with the probation department for the purpose of these reports that are being requested. Probation needs to meet with you and interview and conduct some tests so they can get the information they need to prepare these reports. It's obviously important that when you meet with them, you're open and honest with them, because they're going to check and verify whatever you tell them. And if they learn you're misleading them in some way, it could be as minor, maybe just minimizing or exaggerating something, or flat out lying, whatever the case may be, they'll let me know that, and I would consider that sentencing. So obviously it's important to be open and honest with them. I think that covers everything. Is there anything else that needs to be addressed, Mr. Donnie, that was omitted that you'd like to address?
The only thing that I brought up that I thought of was for the 1320 case. I don't believe this is the paperwork, but there will be a violent offender registry. I know that's not until sentencing, but that advisement was not in there for purposes of count 2, the kidnapping. That was it.
Well, that will be done at the time of sentencing.
Sure. Thank you.
Ms. Smith, anything else?
Nothing on behalf of him.
This case shows how a routine morning turned into a school zone emergency, drawing parents, deputies, and dozens of responders. The court confirmed every charge and penalty, and the defendant entered a full guilty plea.